Tucson, 2025. A daughter held her father's power of attorney. Durable, notarized, signed years before his stroke. Then the nursing home bill came. $9,000 a month. She sat down to protect the house. Her own father's document stopped her cold. The autopsy shows the paper was valid. Valid for everything except the one thing the family needed. Her name was Carol. Her father was Walter. Walter signed the document at 71. He was a retired machinist who read every contract twice. He was proud that he had planned ahead. He thought he had handed his daughter the keys. He had not. And Carol would not learn that for 4 more years. Carol was 52. She had a job, a mortgage, and 2 kids in college. She was not trying to get rich. She was trying to keep her father's house, the house he bought in 1979 and paid off by hand. When the stroke came, she did everything a careful daughter does. She showed up. She read the document. She believed it was enough. It was the document that let her down, not her. A power of attorney comes in 2 shapes. Most families never learn the difference. A durable power survives incapacity. It keeps working after a stroke. A springing power waits. It only wakes when a doctor certifies the person can no longer decide. That certification can take weeks. By then, the emergency has already passed. Walter's was durable. That part, the family got right. Here's the part almost no one checks. A standard power of attorney does not let the agent give money away. It does not let her move the house. Under the Uniform Power of Attorney Act, those are called hot powers. Making gifts, transferring assets, changing who inherits. They exist only if the document grants them in writing. Walter's document never did. And there is a reason so many documents leave them out. Those same powers are how agents steal. A power to gift is also a power to drain. So cautious lawyers strip the hot powers out to protect the parent. The result is a safer document that cannot plan. Most families never see that trade until the day they need the powers that are missing. So what does the right paper actually unlock? With express authority, an agent can retitle a home into an irrevocable trust. Held there long enough, the home stops counting against Medicaid. But the clock is a 5-year look back. It counts the 5 years before you apply, not the diagnosis. So the move only works early and only by the right hands. A power of attorney is what puts the right hands in reach. Without it, the family waits on a court while the window closes. So watch what happened. Walter's stroke hit in March. The care bill was $9,000 a month. Carol wanted to move the house into a protective trust before Medicaid counted it. It was a sound move. She had the wrong paper. The bank refused her. The elder law attorney refused her. Without express authority to transfer, she could do nothing. There was only one path left: a court. To gain the missing powers, Carol had to petition for guardianship. That meant a judge, a lawyer, and a doctor's report. It meant months of waiting and thousands in fees. And even then, a court watches every move a guardian makes. While the clock ran, the spend down ate the savings. Every transfer also faces a 5-year Medicaid look back. By the time a judge could act, the equity was gone. Carol took unpaid leave to file the case. She sat in a courtroom to ask a judge for power over her own father. Strangers reviewed his bank records. The court named a lawyer to represent him. Every dollar she spent for him had to be reported and approved. The guardianship meant to help became a second full-time job, and none of it moved fast enough to beat the bill. The counsel's note: this is not a story about a careless lawyer. The document was valid. The notary did everything right. This is a story about one power no one thought to ask for. This rule is not the same in every state. More than half have adopted the Uniform Act. California, Florida, Texas, and New York each handle agent gifting differently. Some states use a statutory form with a separate gifting section. Leave that section blank, and the agent is powerless. A few states imply small gifts. Most demand the words on the page. Drop your state in the comments. Tell us which rules you are living under. The files we have opened show three things. Three things separate the families who keep the house from the families who lose it. 1. The power names the hot powers out loud. Gifting and asset transfer, granted in writing with limits the family chose. A general power that stays silent on gifts is the silent failure. And a lawyer's signature does not settle this. Many drafted forms still leave gifting out unless the family asks for it. The question is not who prepared the document. The question is whether the hot powers are named inside it. Read the form. Find the gifting section. See if it is filled in. 2. The power is durable, not springing. It works the moment it is needed. It does not wait on a certification. A springing clause sounds careful. In a crisis, it becomes a locked door. 3. The power is built to be accepted. It names a backup agent. It is recent. Banks and care facilities reject stale or unfamiliar forms at the worst moment. Many families learn this at the teller window, with a parent already in care. But there is a second danger, and it points the other way. A power that grants everything with no limits is how savings vanish. We have read the files where a caregiver drained an elderly couple's accounts. The fix is not more power. It is the right powers, with guardrails, named limits. A backup agent who watches, a yearly accounting. Now, meet a second family, the Harmons in Florida. Same event, a father's stroke. The same $9,000 months. But the Harmon's power of attorney named the hot powers in writing. It set a gifting limit. It named a second daughter as backup, so their daughter moved the house into a protective trust in weeks. No court, no guardianship, no frozen savings. They kept roughly $300,000 in home equity. Same disaster. Opposite paper. Opposite ending. Carol's family, or the Harmons. Tell us in the comments which case is closer to your own. Before this file closes, 3 things the cases keep showing. First, read whether the power grants gifting and asset transfer in writing. A durable power alone is not enough. Second, confirm it works on signing, not on a doctor's note. Third, confirm a bank will actually honor it, and that limits and a backup agent are in place. Many families check all of this with an elder law attorney before a health event, not after. Next week, we open another file on an elder law rule that quietly costs families the house. The file closes here. Yours does not have to open the same way. The counsel's note. This is not legal advice. Power of attorney and Medicaid rules vary by state and change often. The cases here are illustrative of documented pattern failures. Many families consult a certified elder law attorney before signing or transferring assets.